Hello and welcome back to another session of Capital Market and Securities Laws. In this session, we are going to deal with the topic delisting of equity shares. This forms a part of lesson number 15 of your syllabus. The delisting of equity shares is regulated or governed under the SEBI delisting of equity shares regulations of 2021. If you don't know me, I am Swathi Sharma, a practicing company secretary and a faculty at Ekcel Academy where I teach the law subjects. Let's dive into the discussion of delisting of equity shares. But before understanding the provisions of the regulations, let's have a look at the basic foundational concepts to have the clarity and understand why these regulations were brought into force and why they are framed in a certain way. So what is the basis? Basis is categorization of companies. So we know that the companies can be classified on various ways, on various phenomenons. But our entire broad classification is going to be in relation to this topic as private and public. So we have private companies, public companies. Public companies are further classified as unlisted public companies and listed public companies. Our entire discussion in today's session is going to be on the topic or in relation to the listed public companies. But what is the difference between these categories of companies? Private companies are the companies in which you have restrictive shareholders. It is a closed organization. You cannot have more than 200 shareholders. It is a restricted organization. You cannot call the public at large to become the shareholders of your organization. Coming to classification of public company, it is further classified into unlisted and listed. What is the difference? Here, again, in both the categories, there is no maximum limit of how many shareholders can be there. It can be beyond 200, any number. There is no upper limit or cap that has been established. But the difference is here you are calling public members from a certain group. It is not to public at large. You're calling investment from outside of the organization, from the public, but not public at large. It is a selected group of people whom you are giving an invitation to subscribe to the shares of your organization. On the other hand, in the listed company, we are issuing the prospectus to the public at large. Any member from among the public can become the shareholder of these kind of organization, and these kind of companies are the companies which are registered with the stock exchange, and that is why they say that they are listed on the stock exchange, and the shares of these companies are traded on the platform that at any point in time any person can buy and sell the shares from the stock exchange if that is listed on the stock exchange. Now, why will a company want to list itself on the stock exchange? Let's assume there is this company ABC. Okay, earlier it was a private organization. Now it has established the foundational business. Now it is looking for expansion of its business. For expansion of business, it requires a lot of funds. It is a private limited organization. It is set its business. It has future prospects. It is looking for expansion for which it is going to require a lot of money. From where are they going to get this money? All the source they have seen, all the possibilities they have identified, all the advantages and disadvantages of borrowing money from banks or taking money from public at large. They have weighed all the options available, and they have decided that we are going to become a public company where we are going to take the investment from the public at large. So what are they going to do? They are going to convert themselves into a public company. Once they do the conversion of becoming a public company, then they are going to contact the stock exchange and ask them the permission and sign an agreement called a listing agreement. Once they sign the listing agreement, obviously we have issue of capital and disclosure requirement regulations where the procedure of IPO is given, conditions etc. are given. But I am just giving you the clarity of why we are going to list and what is delisting. So here what we are complying with ICDR regulations and we are entering into the listing agreement with the stock exchange. After this, the shares of the company will be available or traded on the stock exchange, that at any point in time people can buy and sell the shares of the company on the stock exchange. So this entire process of making the name of the company registered on the stock exchange is called as the process of listing. We have listed our company, we have registered our company on the stock exchange so that people can buy and sell the shares in the open market. Now, what is delisting then? What is the procedure of delisting? Delisting is when we are deregistering, we are removing the name of our company from the stock exchange. We don't want to continue to be traded on the stock exchange. It could be for various reasons, which we are going to cover when we see the regulations. So what is delisting? After registering on the stock exchange, if you don't want to continue on the stock exchange or your trading has to be stopped for any reason, then we are going to apply the concept of delisting, removing the company from the stock exchange. This is the concept of delisting. Now let's get into the basics and see what is a listed company. It is a public company whose shares are traded on a recognized stock exchange. A company is said to be listed when it has gone through the entire process of initial public offer and the shares are available for buying and selling on the stock exchange. So whenever the company registers itself for the first time on the stock exchange, that procedure is called as IPO. Without a IPO, listing is not possible. That is the first step of listing. So a company is listed if it has done an IPO and its shares are available on the stock exchange for the purpose of trading. This is a listed company. Now, listed company can be delisted when we are going to remove the company's shares from being traded on the stock exchange. Once a company is delisted, its shares can never be again traded on the stock exchange. It is permanently deleted from the platform. The public cannot buy and public cannot sell the shares of the company which have been delisted. It will not allow you to place orders with respect to the shares of the company that has been delisted. So this is the process of listing and delisting. Now what is the consequence of delisting? Now we listed because first we needed money, and when you need money, the shareholders are ready to give you the money when their money is not going to be blocked. If your shares are listed on the stock exchange, you are getting as a shareholder liquidity. What is liquidity? How quickly you can convert your asset into cash. Once your shares are listed on the stock exchange, the public shareholders can immediately place an order of buy and sell, and within some time, within a few days, now trading cycle is T plus 0 days for a few segments. So within the same day, you are able to convert your share into cash. You can sell it at a given instant moment, right? That is liquidity. So the advantage of being a listed entity is there is liquidity. People can buy and sell whenever they want. But once your organization becomes a delisted organization, then it has a separate implication on the shareholders, it has a separate implication for the company. What is the implication for the shareholders? That because the company is going to be delisted, they cannot continue trading activities. That means shareholders will not be permitted to place the order of buying or place the order of selling of their shares. Okay. Now, it is bought, you already have the shares. They are not going to allow any other shareholder to buy the shares, and people who are already holding the shares, they will not be permitted to sell the shares. So that liquidity element for the shareholders is automatically lost when a company is changed from a listed entity to a delisted entity. So what is the implication for the shareholder? That they are, because the company is no longer allowed to be traded on the stock market, it makes the entire investment in the share of that company illiquid. That means you cannot place the order of buying and selling, which is a negative aspect for the shareholders, because on any future date, if they want to sell the shares that they are holding, they have to go in search for a buyer. It is not going to happen online over the platform. That is a drawback, and that is why it is very difficult to be a shareholder of a company that is delisted. Second one, when it comes to the company, the advantages, it is going to become either a public unlisted company or it is going to be a private organization, which means that the compliance requirement, the regulatory requirement is minimal. You are more answerable, you have higher level of compliance, you have more legal provisions when public at large is involved, when the public at large has given their money. But in this case, public at large will not be involved because you have delisted yourself from the stock exchange, you are no longer a trading organization, so you will have lesser regulatory compliance in comparison to being a listed entity, and you're going to lose access to the public capital market. Again, you're going to go one level down by not being associated with the public shareholders. So these are the implications of delisting of shares on the company as well as on the shareholders. Now let's get into understanding how these delisting regulations of 2021 have been brought into force. This is again slightly historical perspective of how the regulations of 2021 have come into force. So earlier there was the concept of listing. We know that SEBI as an organization was established in the year 1992 by the passing of the SEBI Act of 1992. So they created ICDR regulations, they created the LODR regulations, all that was fine. But with respect to the delisting of shares, we did not have a specific law. So in the year 2002, they created a committee on delisting of equity shares, and the role of this committee was exclusively to examine and review what should be the conditions for delisting of securities and suggesting what should be the norms that we should follow and what are the procedures that we should follow in case a company want to delist itself. So the committee was created and they had to do all this background work of what should be the procedure, what should be the conditions, when delisting should be permitted, when delisting should not be permitted. A background check was required to be given and they had to submit a report. They submitted their report in the year 2003. And they gave us a basic guideline, okay. The committee worked and they created a structure and they gave us the delisting of securities guidelines of 2003, which was adopted by SEBI. In 2006, mere guidelines are not enough because guidelines are only directives. They are not mandatorily applicable. So in that case, we thought that it is not sufficient for us to have mere guidelines. We have to have a set protocol and regulations and legal provisions, and that is why they proposed the delisting regulations by a concept paper, and public comments was called for the proposed regulations. They drafted the regulations and they put it out in the public domain for seeking representations from whoever is associated in the market, from the public at large, whoever is going to be implicated or affected by these regulations. We put it out in the public domain and said that these are the draft regulations. This is what we are planning to implement. If you all have any suggestions, if you all have any feedback, you can give us your valuable feedback. In 2006, we started the process, and in the year 2009, finally, after taking into consideration the report, the consultation paper and the legal representations or any public representations, we passed the SEBI delisting of equity shares regulations of 2009. Once these regulations of 2009 were brought into force, the guidelines of 2003 were not having any impact. They were repealed, kind of not having any kind of impact. Now, 2009 regulations were there. Then what happened? Then what happened is a lot of changes, and the year 2013 came in. There we have passed the Companies Act of 2013. Now, before 2009, we had the Companies Act of 1956. At that point in time, the legal provisions with respect to regulating companies were slightly different. We have migrated to Advanced Company Law, Companies Act of 2013. So 2009 regulations were in compliance with the Companies Act of 1956. But when Companies Act was modified in the year 2013, there was certain mismatch between the regulations of 2009 and the Companies Act of 2013. So for various reasons, we thought that the delisting regulations of 2009 were not sufficient to handle the situation, changing circumstances and the change in company law provisions. That is why we decided that we have to not only amend the SEBI delisting regulations of 2009, but let's completely repeal the old regulations and completely bring in a new set of fresh regulations for delisting of equity shares, and that is how in the year 2021 SEBI has passed the SEBI delisting of equity shares regulations of 2021, mainly for streamlining and strengthening the entire delisting procedure as well as regulations. So the major reason for why we had to shift between 2009 to 2021 regulations, first one is enhanced disclosures. We wanted more transparency. Situations were changing. There were fraudulent activities that we identified were still taking place, even though the regulations of 2009 were there. So in that case, we wanted more disclosure requirement to bring in more transparency. That is why we had to make the regulations stricter. We had to change the regulations to refine the process, to make it simplified, to ease it for the organizations which are opting for voluntary delisting, and the entire procedure should be seamless without any difficulty. For that, we had to make changes to the procedural requirement. Timelines under the delisting regulations of 2009, strict timelines were not there. The delisting procedure could take a lot of time because they had not specified number of days within which a particular step is required to be completed. But in 2020-21 regulations, they have clearly mentioned timelines and put a maximum cap that the delisting procedure should get over within so many days. Streamlining to make it more efficient, robust, transparent and consumer friendly, that is the investor friendly. To plug the gaps, we have created the regulations. Now the regulations are in force from 2009 to 2021. During this timeline, the regulatory authorities can identify where improvement can be done, what is the gap, how companies are thinking, how investors are thinking, what is the gap between practical application of the regulations and the theoretical regulations, how we can remove that gap, how we can add in more regulations where there are loopholes. So for these things, they thought that it is better that we create a new set of regulations. And lastly, like I said, because the Companies Act of 2013 was brought into force, 2009 regulations were not in total compliance with or in sync with the Companies Act of 2013. That is why we had to change and update the regulations of 2009 and bring a new set of regulations in the year 2021. And we are going to study these regulations of 2021, that is SEBI delisting of equity shares regulations of 2021, which is latest and subject to the amendments which have been made after passing of these regulations. Okay, let's get into the applicability of the regulations, which is under regulation 3. To which kind of organizations is this regulation applicable? Straightforward answer, only if a company is listed, then it can list itself. It is an unlisted public company, the regulations will not be applicable. So this is applicable for any category of listed company which has listed its equity share on a recognized stock exchange. So it is applicable to delisting procedure of equity shares of any company which has been recognized on any registered on any recognized stock exchange and where the shares of that company are listed. So if you are listed on BSE, then you have to undergo delisting procedure for delisting your shares on BSE. If you registered yourself on both NSE, BSE, you have to then make a choice. We will discuss these provisions later. But what is the applicability? It is applicable to every listed company which has listed its equity shares on the stock exchange and they are looking for delisting themselves. They are looking for deregistering themselves, or the authorities are thinking of delisting these organizations. Then this particular regulation will become applicable. It is not applicable to certain kind of delisting. When is it? When it is listed on the innovators growth platform without going through the procedure of IPO. Okay. In the basics of capital market class, I have already covered this difference. If you are a startup company, there are two options provided. One is registering the company on the innovators growth platform, and this is without the involvement of any investment or any money from the public at large. We are not taking money, we are not raising funds, we are not raising any investment. We are only registering our company on the platform to get the recognition. On the other hand, you have one more option where you are going to register yourself and you are also going to list yourself. Listing means you are raising an investment. You are raising funds from the public at large. So, if your intention is only to register, you have not taken any money from the public at large, then there is no need for the delisting procedure. Delisting procedure is only for the security and safety of the people who have made an investment in that company. You should give them an opportunity to exit the organization, because the company is going to become illiquid now. It is going to be, the shares of the company are stopping from being traded on the stock exchange. So, mainly these regulations are for protection of the shareholders who are associated with the listed entity. Here, because there are no public shareholders at all, you have only registered yourself. So, this is the listing without IPO. That means you have not raised any money. If you have taken the money from public at large and you are delisting yourself from IGP, then your regulations will become applicable. But if you are a startup and you have registered yourself on the innovators growth platform without making an initial public offer, then delisting regulations will not be applicable, merely on the ground that you have not taken any money from public investors. So, delisting regulations will not become applicable. Next, you are undergoing delisting procedure because of a resolution plan which has been approved under the Insolvency and Bankruptcy Code. You are not voluntarily wanting to delist your organization, or neither it is a punishment that is going to be given by the regulatory authorities to delist the organization. It is merely because your organization has suffered, it is a sick unit. It is becoming insolvent. We are planning to revive the organization. To revive the organization, it is essential that it has to be delisted. So, if it is going or undergoing the procedure of delisting because a resolution plan requires the company to be delisted, then those kind of delistings, this regulation will not become applicable. Next. It is also not applicable to the price for the public shareholders. If the existing public shareholder shall be, they are required to be given an exit opportunity at a certain price. What does this mean? It means that now you are a listed company. Why did you become a listed entity? Because you wanted to raise money, you wanted to raise funds for the purpose of expansion or whatever. Now, what has happened here? Public shareholders are involved, public at large, a lot of crores of people have given their money to this company to expand their business. This is the process of listing. When the company is going to be delisted, what is going to happen? Still the shareholders' money is going to be involved with that organization. Now, through delisting, we are cancelling the trading of shares. That means people will not be permitted to buy, people will not be permitted to sell the shares of the organization. In that case, what should we tell these public shareholders? Should you mandatorily continue to be the shareholders of the organization? No, because they have made an investment because of the main important category, that is liquidity. Because there is liquidity of investment, immediately you can sell, immediately you can buy. Because of that feature, people are making an investment in the equity market. If that liquidity liquidity itself is lost, you should ask them, are you ready to still continue with the company if the trading is going to be stopped? So two options are going to be given to the shareholders of the organization. One is the exit opportunity. That is, I am invested in the equity market merely because of liquidity. If the company is going to become a delisted entity, I don't want to have the shares of that company. I want to sell it off. So what is the exit opportunity? Where the company itself is going to buy the shares of the public shareholders. The promoter group members are required to buy the shares from public at large and ask them to exit the organization. Second category of shareholders are that we are invested in the company because we believe in the company. Whether it is trading, whether it is not trading, whether it is listed, whether it is unlisted, we don't care. We believe in the company. Even if it is delisted, we want to be associated with the company. We don't want to take the exit. We don't want to take the money and leave the organization. We will continue to be associated with the company irrespective of what is the listing status. So those kind of shareholders can continue to retain the shares of the company even after delisting. This is the choice of the shareholder, what option he wants to select, whether he wants to take an exit opportunity. In this case, the promoter and promoter group members are going to pay an exit price to the public shareholders. They can take that money, all the investment that they have made, they can take the value and exit the organization. Or they have an option of retaining the shares even when there is no liquidity, even when they cannot be traded on the stock exchange, they want to continue to hold the shares. That is the option that we are going to give. So what are they telling here? They are saying that at what price should the promoter and promoter group members take the shares from the public shareholders. What is it? It should be not less than the money that has been given to the promoter or promoter group members to exit the organization. So at any point in time, the pricing are going to be fixed and it cannot be below a certain set limit. Intimation to the stock exchange, the details that the company is going to delist should be provided along with the justification of the exit price. How did you arrive at this exit price? What is the valuation? All that details within 1 day of the resolution plan being approved under the IBC code, you should inform the stock exchange. So this is with respect to the second point, right? We saw that in two cases, delisting regulations are not applicable. First one is when it is listed on the innovators growth platform without making an IPO, in that case there is no need. Second one, when the company is going to delist itself because it has to comply with the resolution plan under the IBC. So in that case, the pricing, how you are going to become solvent, at what price you are going to give exit to public shareholders, it should not be less than the value that is being given to the promoter group members. And secondly, the details of the delisting procedure, the exit price, everything that has been decided as per the resolution plan passed by the member within 1 day of passing of the resolution plan under the IBC, we have to give an intimation to the stock exchange that we are going to delist via this resolution plan. Because delisting is not applicable, these regulations will not become applicable, but you have to give an intimation to the stock exchange because that is the platform where you are listed. They should delete you from the system. They should delete you from the mechanism where buy and sell order can be placed. So if the stock exchange has to delete the company from its setup, from its platform, information is required to be given. So whenever a company decides to delist itself, because of a resolution plan, within 1 day of passing the resolution plan, we have to give an information to the stock exchange about the proposed delisting and what is the exit price and what is the reason and justification for setting a particular exit price. Now, coming to what are the conditions for delisting, Regulation 4 lays down certain conditions for delisting. They say neither any company shall apply for delisting of equity shares, nor any recognized stock exchange will permit the delisting until and unless certain conditions are satisfied. So company also cannot apply If it is by mistake applying, in that case, recognized stock exchange should not permit when certain conditions are not satisfied. First one, duration of listing. What does that mean? We saw that a company has a procedure that it has to go through, that is initial public offer. In case it wants to become a listed public company, it has to go through a procedure called initial public offer. The duration between listing and delisting should be of at least 3 years. If the company is listed today, after 1.5 years, you cannot say I want to apply for delisting. No, okay. Unless a period of 3 years has elapsed since the listing of that class of equity shares on the recognized stock exchange. So, one category of equity share should be listed on the recognized stock exchange minimum for 3 years if it wants to apply for delisting. Outstanding convertible instrument. That means you all, we have already dealt with the instruments in the capital market, where we saw that there are convertible debentures, there are convertible bonds. What is this convertibility element? Any instrument that can be on a later date converted into equity shares. The bond can be converted to equity shares. Debentures can be converted into equity shares. So, if there is any instrument out in the public domain, you have issued a bond, the maturity period is 5 years. Okay, and you're planning for delisting. If that bond is still valid and conversion is due in a future date, you have to give equity shares in relation to those bonds. In that case, we will not permit you to undertake delisting because there is outstanding convertible instrument. Once that conversion is completed, once in lieu of bond you have given equity shares, after that you can apply for delisting. But when any convertible portion is still present out in the market, you cannot make an application for delisting. Buyback. If the company has done a buyback in the previous period of 6 months, we will not permit for delisting. Similarly, for preferential allotment, if the company has executed any preferential allotment 6 months, just 6 months, within 6 months of making an application for delisting, it will not be accepted. So, these are the conditions that have been imposed for approval of a buyback. Next condition is no acquirer will be permitted to use the money of the company for the purpose of giving an exit opportunity to the public shareholders, and the acquirer should not propose the delisting of equity shares if he himself has sold the equity shares of the company during the previous 6 months. So, these are additional conditions that are laid down. The prime conditions are these 4. No buyback in the previous 6 months, no preferential allotment in the previous 6 months, that no outstanding convertible instrument should be there, and the listing procedure, you should be a listed company for a minimum of 3 years before making an application for delisting. These are the 4 basic conditions. Additional conditions are with respect to that the funds of the company should not be used for exit opportunity for shareholders, and the acquirer himself, if he is selling his shares, he will not be permitted to make an application for delisting. Now, further, again these are additional conditions. No acquirer shall directly or indirectly employ any kind of device, scheme, etc. for defrauding the shareholders, and they should not engage in any transaction to create any kind of fraud or deceit upon public shareholders. Neither the acquirer, that is whoever is buying back the shares in the delisting, whoever is going to give the exit opportunity, whether it is promoter group members or the acquirer under SAST regulations, whoever is going to give them the exit opportunity for the purpose of delisting, that acquirer should not defraud, that acquirer should not fraud and cause deceit upon the public shareholders, and they should not do any kind of fraudulent or deceptive or manipulative trade activity in relation to the procedure of delisting. So, these are the basic conditions that are attached. Now, let us go to the next concept and understand what are the various methods of delisting. One is voluntary delisting, second one is compulsory delisting. What is voluntary delisting? Where by yourself, the company itself makes an application, will apply for a delisting of the shares. Nobody is telling us, nobody is giving us an order. The company itself thinks that it is better if we become delisted voluntarily, self-application. Compulsory delisting is where the company does not make an application, the company does not want to delist itself, but because the company is not complying with the regulatory provisions, it is not complying with the listing agreement, it is not listening to the orders of the stock exchange is punishing the company and they are mandating that you have to delist yourself. We will not permit you to trade on our platform because you're not complying with our orders, you're not complying with the provisions, you're not complying with the agreement that we have entered into. So this becomes mandatory. You have to, it is imposed by the regulatory authority, that is the stock exchange, because it is a punishment. It is a punishment because even after multiple warnings, you are not complying with the legal provisions. So what are the two ways of delisting the organization or company? One is self by the company. The company itself is thinking about the future, or the promoter group members or the acquirer. They have some strategic plan and they are making an application that we no longer want to continue to be a listed entity. We want to apply for delisting, that is self. And compulsory, where it is imposed by the regulatory authority because there is non-compliance as a punishment. Let's see the provisions. A company, when it decides by itself, on own, by self, to remove the shares from the stock exchange, it is called as voluntary delisting. But what are the reasons? Why would a company want to delist itself? One is where the company has stopped to carry on the business itself, where it is reducing. It wants to ultimately shut down, so it is going to apply for delisting. When the company has become bankrupt, when the company has been acquired by or merged with any other entity and that entity is already listed, so you can apply for delisting of this entity instead of continue to be having two separate listed entities. It is better they merge and have one listed entity. So one listed entity that is going to shut down because of merger, they have to apply for delisting. So these are few reasons why self application for delisting is going to be filed by companies. Second category is compulsory delisting. Like I told you, it is going to be removed from the stock exchange by the decision of a stock exchange as a penalty, as a punishment, because they are not submitting the documents as and required, they are not complying with the regulatory requirements as set out in the legal agreement, listing agreement within the timeline specified. And here the company has absolutely no choice in exercising the removal of the shares from the stock exchange. They have no choice, it is mandatory, it is imposed as a punishment. They cannot have the decision in their hand. Here the decision is taken by the stock exchange. Here the decision is taken by the company. That is the difference. Okay, so two categories of delisting are there, voluntary and compulsory. Now, next is classification of voluntary delisting. Now, before going into the concept, let's get few things set. There is a company, company 1. This company is listed on NSE. You have company 2, which is listed on NSE as well as the BSE. We have two separate companies, company 1, company 2. Company 1 is listed only on the NSE and company B is listed on both NSE and BSE. Now, when this company A or company 1 is applying for a delisting, what is going to happen? After the company is delisted from NSE, it has no more platform, no more trading platform available for itself. In this case, it is going to become a delisted entity from across all the platforms. So mandatorily they are required to give the exit option or opportunity to the public shareholders, because absolutely liquidity is going to go. Because once you delete yourself from the NSE, you are not listed anywhere else. So the entire liquidity element is lost. You have to mandatorily give the exit opportunity to the public shareholders. On the other hand, the company 2 is listed on both NSE and BSE. In this case, if the company decides that I want to delete myself, I want to delist myself only from the NSE, but I want to continue to be listed on the BSE, in that case, what is going to happen? In this case, even if the company gets delisted from the NSE, still it can be traded on the BSE. Still liquidity element is present because you can buy and sell your shares on the BSE. In this case, there is no requirement of giving an exit opportunity to the public shareholders because liquidity is still there. Liquidity is going to be maintained because BSE is still there and you are listed. You continue to be listed on BSE. You have only deleted yourself from the NSE. And why would companies want to do this? Because when you sign a listing agreement separately with the NSE and separately with the BSE, compliance requirement is more. You have to submit all the documents to NSE, you have to submit all the documents to BSE. It becomes slightly complicated. So if they decide that we don't want so much compliance, one stock exchange is sufficient, no need both the stock exchange, they can delete themselves from one stock exchange and reduce the compliance requirement. Third situation, company 3. They are listed both on NSE and BSE. Now, what are they going to decide? They are going to decide that I am going to delist totally. We don't want BSE, we don't want NSE. We are going to delist ourselves from both the platforms. In this case also, what is going to happen? Same situation as that of company 1. They are going to totally stop trading because no other platform is available. Both NSE and BSE, they are making an application for delisting. No trading is permitted, so no liquidity is going to be there. Even in this case, mandatorily exit opportunity is required to be given. So what are the two categories of voluntary delisting? Voluntary delisting, one where you are going to delist from all the recognized stock exchange. That means you're not going to continue to be a listed entity at all. Then mandatorily exit offer or exit opportunity is required to be given to the public shareholders. On the other hand, when you decide to delist yourself from only a few stock exchanges, but ultimately you're going to continue to be listed on, at least one stock exchange having nationwide terminal, then there is no requirement of giving an exit opportunity to the public shareholders because other platforms are available. Now, what is going to be the implication? This comes under category 1, where from all stock exchange you are going to delist yourself. This is also coming under category 1, where you are going to delist from all the stock exchange. This comes under category 2, where you are going to continue to be listed on at least one stock exchange. So what is going to will there be a change in the designation? Yes, this will become an unlisted public company or a private company depending on what they want to do. This will also become an unlisted company, but this company, even though it has delisted from NSE, it is going to be continued to be called as a listed entity because it is still listed on the BSE. These are the options. So what? Voluntary delisting can further be classified into delisting from all the stock exchange where mandatory exit offer is required to be given, or delisting from a few of the stock exchange and you continue to be listed on at least one stock exchange. You can still be called as a listed entity, still the shares can be traded, still buying and selling can take place, still liquidity element is there. In that case, there is no need of giving an exit opportunity. So this is about voluntary delisting. Now, basic difference between delisting and suspension. Suspension is temporary. You have done something wrong. We asked you to rectify. You did not rectify it. We are imposing a temporary punishment that this is the value. For so many days, you are not allowed to trade. That is suspension. Delisting is permanent in nature. Once you make an application for delisting or once the regulatory authorities delist you, permanently your shares are going to be removed, deleted from the platform, that is stock exchange. In suspension, we are not deleting. Only for certain number of days we are going to pause where the option of buying and selling will not be provided. Shares are suspended for a certain number of days. It is paused, but here it is permanently deleted. Here there is a pause in trading of the shares. Here there is total deletion. Permanently we are deleting the shares from the platform. Okay. So what is suspension? It is only for a limited period of time. No trade can take place during this temporary suspension period. Not done at the instance of the company. Again, it cannot be voluntary. Suspension is always imposed by a regulatory authority because there is non-compliance, okay, of any provision, specifically LODR regulations and the listing agreement. Once the company makes good the loss, makes good the non-compliance, complies with the provisions, follows all the orders that have been given with respect to the suspension order, after that it is going to be, suspension is going to be cancelled and trading will be permitted. So it is only for a short duration of time that the shares are going to be paused from being bought and sold in the market. On the other hand, delisting is permanent in nature. It is completely deleted from the stock exchange. No further trading is going to be permitted. So these are the two methods of delisting, voluntary and compulsory. Now, in this session, our entire focus henceforth is going to be on compulsory delisting. Voluntary delisting we are going to cover in some other session, because there are a lot of amendments that have been brought about for voluntary delisting. A detailed analysis and longer time is required to deal with the concept of voluntary delisting. So this session we are going to limit our discussion exclusively to only compulsory delisting. What is compulsory delisting? We have already seen. It is an order given by the stock exchange, the regulatory authority, to the company that we are deleting the shares of your company from our platform because you are not complying with the listing agreement and other regulatory provisions. It is a punishment that is imposed on the companies because they are not complying with the requirement. It could be not submitting the quarterly requirements, half yearly requirements, one-time events, not doing the basic agreed terms and conditions as per listing agreement. For all these reasons, we are going to give warning, 2 warning, 3 warning. We are going to suspend. Even after suspension, you are not listening to us, we are going to take the extreme step of delisting you. So this compulsory delisting is the last resort. First, we'll tell you, don't do it. We'll give a warning. Even after warning, you're not going to listen, second warning. After that also you're not listening, we're suspending. Even after suspension, it is not impacting you. Then we are going to go for delisting. So this is the last resort that is being used by the regulatory authorities in case the non-compliance is of continued nature. So what is compulsory delisting? We already know it is permanent removal of the shares of the company from the stock exchange, and it is imposed as a penalizing measure, that is as a punishment. It is imposed as a punishment by the stock exchange. It is the stock exchange which makes the decision of delisting the companies from their platform. Why do they do it? What is the purpose of passing the order of delisting? It is because they are not making submissions and compliance with the requirements of the listing agreement within the time that has been prescribed under the listing agreement. So as soon as you conduct the board meeting which has relevance, suppose you are going to declare a dividend, you're going to discuss in a board meeting, should we give the dividend or should we not give a dividend? That is the agenda of the board meeting. When you're discussing this agenda in the board meeting, prior to conducting the meeting also you should inform the stock exchange. After the meeting is over also you should inform the stock exchange. These kind of informations are not given by the company to the stock exchange. Then they say that there is non-compliance of the listing agreement. Okay. So what is compulsory delisting? It is a punishment imposed by the stock exchange because there is non-compliance by the company, and because there is non-compliance, they are permanently deleting the shares from the stock exchange platform. Next. Regulation 32, subregulation 1 of SEBI, delisting of equity share regulations of 2021, says that a recognized stock exchange can pass an order of delisting, but that order should have reasons. Why are we proposing the delisting of equity shares of this one company? What is the non-compliance? What is the facts of the case? Why this extreme step is required to be taken? Along with reason and justification only, the order of delisting can be passed by the stock exchange, and for that also specific grounds have already been provided under the relevant rules. Which rules? Securities Contract Regulation Rules of 1957. Under those rules, clear set of grounds are given that if this situation occurs, you are permitted to delist the company. So only on those grounds they can pass an order of delisting. So what two things are required? What is the reason for delisting and on what ground you are delisting? Those grounds are provided in the Securities Contract Regulation Rules. But the most important thing is the delisting order cannot be passed by the stock exchange until and unless a reasonable opportunity of being heard is given to the company. Basic principles of natural justice. Without hearing the other party, do not pass the judgment. You think the company should be delisted. You are proposing the idea, but give them a chance to give an explanation. What if they have a valid, reasonable ground for not doing the submissions or not complying with the provisions of law? So ask them why you have done this wrongful default, why have you not complied with the provisions of law, why have you not complied with listing agreement. We are thinking that we are going to delist you on these grounds. Do you have any justification? Do you have anything to say? Ask them. If their answer satisfies you, you give them certain timeline, ask them to rectify the errors and leave it. But if their answers are not satisfactory, then you go ahead and pass the delisting order. So what is the gist? Stock exchange can pass a delisting order, but it should contain the reasons. It should be only on the grounds that is specified under the Securities Contract Regulation Rules. In addition to that, this delisting order cannot be given until and unless a reasonable opportunity of being heard is given to the company before passing the delisting order. Now, the delisting of securities, two provisions. One is, we saw regulation 21 of delisting regulations, but these are also dealt with under Securities Contract Regulation Act and Securities Contract Regulation Rules. Okay, section 21A and rule 21 talks about delisting of equity shares. Briefly, I have included that concept here along with these regulations because it is important to study all the regulatory provisions in relation to the same topic. So, how does delisting regulations are governed? They are governed under three laws. One is the delisting regulations. Then is you have Securities Contract Regulation Act read with the Securities Contract Regulation Rules, and you have the Companies Act of 2013. Certain elements. Okay. Now, let's see what is the Securities Contract Regulation Act have to say. A recognized stock exchange will be permitted to delist the securities only after recording the reasons from the stock exchange only on the grounds that are specified under the particular act, that is under the Securities Contract Regulation Rules. It can be passed only after reasonable opportunity of being heard is given. That means whatever delisting regulations are saying, it is based on the Securities Contract Regulation Act, because when there are provisions in relation to the same subject, both the law should be in sync with each other. One law cannot say one thing, another law cannot say another thing. Then what are the people going to follow? So when there are two different laws on the same topic, generally they are in sync with each other. Same thing is told here. Stock exchange can delist, but it should be for specific grounds and only after giving reasonable opportunity of being heard. If any person is not happy with the decision of a stock exchange to delist its company from the stock exchange, they have a right to prefer an appeal before the Securities Appellate Tribunal within 15 days of the decision of the stock exchange. But this 15 days period can further be extended to 1 month if there is sufficient cause and a justification of why you cannot file an appeal within 15 days. Extension of time can be given by the Securities Appellate Tribunal. So, extra point is being added here, the appeal provision. If the stock exchange decides to delist the company delist the shares of the company, in that case, they have a right to appeal before the Securities Appellate Tribunal within 15 days of the decision that is taken by the stock exchange. Rule 21 lays down what are the grounds for delisting. This is specified in section 21 of Securities Contract Regulation Act and also under regulation of the delisting regulations. Under both these provisions, they have clearly said that stock exchange can delist with reason, but only on specific grounds. Those are the grounds which are specified under Rule 21 of Securities Contract Regulation rules. Let's see what are the conditions. We are talking about compulsory delisting. That means this is imposed by the way of penalty. Okay, what are the grounds? One is that the company is consequently seeing loss and negative net worth. The company is not adding value to public shareholders. Public shareholders are losing their money to a greater extent because of the bad performance of the organization. So, the company has incurred loss during the period of 3 consecutive years and it has also negative net worth. What is net worth? Where the liabilities are more than the assets. So, when you have loss but you have a positive net worth, that means you can somehow pay back the money to the public shareholders because of disposing your excess assets that you have. But when you have only liabilities and you're only going to make losses, how are you going to return the money to the public shareholders? It is going to be difficult. Okay, in that case, if we are going to see a performance over a duration, because they may improve in future. So, we are going to wait for 3 years. Even after 3 years, if your performance is terrible and you have a negative net worth, then we are going to give you an application, we are going to give a proposal for delisting that company. Suspension. If the company's shares have been suspended by the stock exchange for a continuous period of more than 6 months, we are giving you warnings, we are giving you suspension orders, but still you are not improving yourself, still you are not complying with the provisions, then the stock exchange is going to give a ultimatum that we had given you suspension order, multiple suspensions have been done, but still you are not complying, we will pass the delisting order. Infrequently traded. What is trading? Buying and selling on the stock exchange. How many people have bought the shares of the company in one day? How many people have sold the shares of the company in one given trading day is what we are going to see. If the number of transactions of purchase order or sale order of the shares of a particular company are significantly less, we say that it is infrequently traded. Again, numbers are provided. Definition is there, what is frequently traded, what is infrequently traded. For now, you understand if the number of transactions of buying and selling the shares of the company is not good enough, we say it is infrequently traded. That means people are not interested in purchasing and selling the shares of your organization. They don't want to associate with your company. In that case, if the securities have remained infrequently traded for 3 years, we are giving you time to build. But for 3 years, if you are infrequently traded, we can make the authorities can give you a delisting order. Conviction. Conviction means you are held guilty for a wrongful act. So, whether the company itself, where any promoter member, any director of the company has been held or been convicted for failure to comply with the provisions of SEBI Act, provisions of Depositories Act, provisions of any of the rules or regulations made under the SEBI Act and delisting regulations, and not only that, you should be held liable for failure to comply. In addition to that, penalty of not less than 1 crore rupees or imprisonment of not less than 3 years has been imposed on the company, director or promoter. Then we say there is conviction. You have done a wrongful act, they have decided that it was wrongful, they have given you a fine or penalty of 1 crore, they have given you an imprisonment of up to more than 3 years. In that case, on the grounds of conviction, we can delist the company. Incorrect address, where the address of the company is not updated, you have not told the address, they are absconding, you don't know the details of the director's address is wrongfully given, where you are not able to trace the exact location. Okay, in that case, it can be delisted. Fall in minimum public shareholding. fallen minimum public shareholding. The law says that once a company becomes a listed entity, we are going to fix limit. At least this much share should be held by the public. This much share should be held by the promoter group members. What is the maximum what the promoter group members can hold? All those limits are clearly specified under the Securities Contract Regulation Act and Securities Contract Regulation rules. Rule 19 and 19A, to be specific, clearly provides. So when you have the clearly prescribed minimum public shareholding limit and it falls below that limit, and within the reasonable time you have not increased it back to the required limit, in that case we say that the public shareholding has fallen below the minimum level. In that case also delisting order can be passed by the stock exchange. So what are the grounds? You have loss along with negative net worth. You are held or convicted for a wrongful offence. Your shares are infrequently traded. There is suspension for more than 6 months. Address is incorrect, and the public shareholding has fallen below the minimum required limit. On all those grounds, the stock exchange can pass an order of delisting. This is the basic. Now let's assume that the stock exchange has identified a company, that these are the grounds on which this particular company can be delisted. What are they going to do? They are going to, as a first step, constitute a panel who are going to decide whether delisting is required in this given facts, or we can just rectify it by giving them suspension, warnings, etc. Whether alternative mechanism is there, or should we go to the last resort and delist the company. To discuss that and come to the final conclusion of whether delisting should be done or should not be done, to decide that question, we are going to constitute one panel. Okay, the decision regarding compulsory delisting is going to be taken by a panel, okay, to be constituted by the stock exchange. The stock exchange is going to create this panel, which is going to have 2 directors from the stock exchange, 1 representative from investor association, 1 representative from the Ministry of Corporate Affairs or a registrar of companies, and the executive director or the secretary of the recognized stock exchange. These people are going to be on the panel, and they are going to do the discussion and come to a conclusion of whether delisting should be done or not done. If they come to a conclusion that delisting should be done, what are they going to do? They are going to give a public notice before giving the order to the company. What should we do? We should give a public notice. What is it? Before passing the final order of delisting, we know reasonable opportunity of heard should be given to the company as well. You should hear the company before passing an order. Reasonable opportunity of being heard. In addition to giving the notice to the company itself, we should also give a notice to the public at large. The recognized stock exchange is required to give a public notice in at least 1 English national newspaper having wide circulation, at least 1 Hindi national newspaper having wide circulation, and at least 1 vernacular newspaper, that is local language, where the recognized stock exchange is located, at the location of the stock exchange. The regional language that is spoken, vernacular language, that language. In these 3 kinds of newspapers, you are required to give a public notice that the stock exchange is proposing to delist this company for so and so grounds. What should be the details in the notice? The details will be that we are planning, it is proposed, we are discussing, we are proposing to delist, by giving them a period of 15 working days to give any representation. If from public at large anybody has an objection that no, the company should not be delisted, if you have some thought, if you have some suggestion, if you have some representation to make, or if you are personally involved as a shareholder, even then you can make a representation to the recognized stock exchange if he is going to be aggrieved by delisting. If the company becomes delisted, it is going to negatively impact you. as a member of the public, you can make an objection or you can raise your representation before the stock exchange. That is why we are giving a public notice. If by delisting this company, are you going to be impacted? You tell us. So we are going to give 15 days time to them through public notice to send their representation, if any. The display of this public notice should also be done on the trading systems and the website. Online trading platform will be there. So on that platform, NSE, BSE, whichever, and their website, everywhere this notice should be displayed. That is the first step. Constitution of the panel, if they decide that okay, we will go ahead with the delisting, they should give a public notice. Next, delisting order by the recognized stock exchange. You have given the public notice, you have received the representations from them, you have heard the company, you have heard the people from public at large. Now after seeing everything, after hearing all the parties, you have to make a decision. The recognized stock exchange, while passing the order of compulsory delisting and after considering all the representations made, if any, by the company and by the representation received in response to the public. Okay, this is from the company because we send them the notice of giving an opportunity of being heard, and this is public notice. Whether the company has to say anything or whether public at large has to say anything. After taking all the response into consideration, they can pass an order of compulsory delisting of the company, and they should comply with the guidelines provided in these regulations. The stock exchange is required to follow certain guidelines when they are going to go ahead with the delisting of the equity shares of a certain company. But what are the delisting guidelines? They are specifically provided. First one, the recognized stock exchange should take into account the grounds that are specified under securities contract regulation rules. We have already covered Rule 21, right? It should only be in accordance with those grounds specified. The recognized stock exchange should take all reasonable steps first to trace the promoter and promoter group members which is proposed to be delisted. We told sometimes the address is not correct. They have given incorrect address or they failed to update the address. If they are absconding, in that case, the stock exchange first should make an attempt to trace everybody. If it is after all the efforts you are not able to trace, then it is different. But it is your responsibility to at least make an attempt to trace where the promoter group members are, what is the address, etc. The recognized stock exchange should consider the nature and extent of the alleged non-compliance. What is the wrongful act that they have done? Is it so severe that you are going to the last resort of delisting the company, or it can also be handled by just giving them a suspension? So the stock exchange should actually consider what is the nature and what is the extent of non-compliance by the company, the number and percentage of public shareholders who may be affected by this non-compliance. What is the impact of non-compliance? If the non-compliance is only administrative in nature, it does not have impact on the public shareholders, then we will not delist. But if the non-compliance is a fraud, if the non-compliance is total, kind of impacting the price of securities, it is going to impact the public at large. In that case, that non-compliance cannot be taken very lightly. It has to be taken seriously because it is ultimately impacting the public shareholders at large. So in that case, we are going to go ahead with the delisting. So you should see what is the nature, what is the impact of non-compliance, what is the event that has taken place. After taking all these factors into consideration only, they should decide whether mere warning suspension is sufficient or should we go ahead and do the delisting. Next, the recognized stock exchange should take reasonable efforts to verify the status of compliance of the company from the register of companies as per the compliance requirement required with the Ministry of Corporate Affairs. Even under Companies Act, if there is a listed entity, they have to comply with SEBI regulations, they also have to comply with Companies Act. So they are non-compliant with SEBI regulations, but are they compliant with the Companies Act? You have to ask the Ministry of Corporate Affairs. You have to ask the ROC, have they done the company law filings? Have they done all the submissions? You are going to verify. Are they non-compliant everywhere or they are non-compliant only with respect to certain SEBI regulations? You should cross-verify those details. the names of the companies whose equity shares are proposed to be delisted and their promoters should be displayed in a separate section of the website of the recognized stock exchange. If delisted, the names will then be shifted to one more separate segment on the website. So, on the website of the stock exchange, a lot of details are going to be there. So, where you are trying to identify companies, promoter group members, which is proposed to be delisted, all those names should be reflecting on the website that these are the members whose companies are proposed to be delisted. Once the company is delisted, we'll delete their names and we are going to put it in one more segment where delisted shares are going to be specified. The recognized stock exchange shall file appropriate cases and file prosecutions under relevant provisions of Secretaries Contract Regulation Act or any other law for the time in force against identifiable promoters and directors who are held liable for non-compliance. Merely delisting is not sufficient. Because it has impacted public shareholders, because there is non-compliance, because there is failure, because there is some kind of fraud, we will also file cases against them. Case plus delisting. Because you have delisted does not mean that we are not going to take any action against them. Delisting is for the protection of the public shareholders, but because you have done a wrongful act, case is also going to be filed, penalty is also going to be imposed. If required, imprisonment is also going to be given for all the people who are associated with that non-compliance. So, merely because we are going to the last resort and ordering delisting does not mean we are going to neglect the case. Case is going to go on, but we are delisting the company for ultimate safety of the public shareholders. The public notice after delisting order. So, two kinds of public notice are required. One is initially, before passing the delisting order, we are asking public to give representation. If we delist the company, are you going to be impacted? If you are impacted, please write to us how and why we should not delist this company. After taking the representations of the public and the company, they have decided and passed the delisting order. After delisting order has been passed, one more second public notice is required to be given that we have delisted, we have passed the order of delisting. Where the recognized stock exchange has finally passed the delisting order, it should publish that detail in the newspaper. Same thing in one English newspaper, nationwide terminal, one Hindi newspaper, nationwide terminal, the wide circulation, not terminal, nationwide circulation of English newspaper, Hindi newspaper, and one vernacular language. Okay. The details that should be there in the notice is the fact that we have delisted the company, the name and address of the company that is being delisted, what is the fair value of delisted equity shares, name and addresses of the promoters of the company who are held liable for non-compliance. With all these details, this public notice is going to be published in the newspapers, not only in the newspapers, but it should also be published on the website of the stock exchange. And we should inform all other stock exchanges, like for example, if BSE has identified that there is non-compliance on this particular company and this company is required to be delisted. Delisting order has been passed by BSE. Now it becomes the responsibility of BSE to communicate to NSE that see, this is the company, this company is also listed on your stock exchange, you see whether they are complying with your listing agreement or not. We have identified severe non-compliance and we have taken the last resort of delisting this company. You also verify, cross-check. If there is a requirement, you also go ahead with delisting. A warning is given. Because a person who is non-compliant in one place, there is a high probability that he is also going to be non-compliant on other platform. So, if a company is listed on 2 or more stock exchanges, in our country only 2 are there, NSE, BSE, which is having nationwide terminal. In that case, if they are registered on or listed on both the stock exchanges and they are delisted from one stock exchange, it becomes the obligation of the delisting the stock exchange which has passed the delisting order to inform the other stock exchange about such facts and circumstances. So, you should inform the other stock exchanges about the delisting order passed against a company which is also listed other. Now, what are the rights of the public shareholders if a compulsory delisting is passed? What will happen? First, appointment of independent valuer. Why? Because public shareholders are not going to leave the company just free of cost. If they are being exited, it is permanently going to be deleted from the stock exchange. That means trading is not going to be permitted. In that case, we are going to give them some money in exchange of taking their shares. We are going to give them prize for giving their shares back to the promoter group members or members. So in that case, a fair value is required to be determined. What money should you give to the public when you're taking back the shares from them? That is going to be decided by the independent valuer. So the first step becomes appointment of an independent valuer for the purpose of determining the fair value. And how are we going to appoint this independent valuer? There is going to be a panel of expert valuers. From that panel, you are going to have a panel there, all the valuers are going to be registered. From among those registered valuers, expert valuers, we are going to identify one person, we are going to appoint one person as an independent valuer for our particular case. We are going to appoint them for a particular purpose, that is determination of fair value. We have to give money to the public shareholders for taking the shares back from them. At what value should we take it back? That is the fair value that has to be determined by this independent valuer. Fair value. The value of delisted equity share shall be determined as prescribed generally according to the valuation rules. Next, right to tender the shares means they have a right, they have an option of giving back the shares of the company. They still have a right to retention. Even under compulsory delisting, the shareholders have two options. One is to take the exit opportunity, exit offer, or one more is continue to retain the shares. It is absolutely the choice of the shareholder, even under compulsory delisting. Only if they compulsorily don't want to be associated with the company, only if they are not okay with illiquid investment, okay, then they are going to take the exit offer. If they are so confident and have conviction with the company's performance, they can continue to retain the shares of the organization. Same thing, either you tender your shares or you retain the shares. One of the two options you have to select. Right to interest for delayed payment. Once the delisting order has been passed, fair value has been determined, the value, the money should be paid to the public shareholders. That is the purpose. If you are not paying the money to the public shareholders within the given timeline, interest is required to be paid for the delayed payment. Okay, 10% per annum is the interest that has to be paid for delayed payment to the public shareholders of the fair value that is determined if they have tendered the shares to the company. Now, what are the consequences of compulsory delisting? Once a company has been compulsory delisted, can it again make an application for listing on the stock exchange? What is the implication? What is the impact of delisting order? First one, where a company has been delisted, that is compulsorily delisted by the way of a punishment, the company, whole-time directors of the company, every person who is responsible for that non-compliance, all the promoters of the company and all the companies which are promoted by the same category of people, all these kind of people will lose access to the securities market. They will be banned and prohibited from accessing the securities market, or also they will not be permitted to list any of the equity shares for a period of 10 years from the date of delisting. So you are banned for 10 years for making one more application for listing of your company. Okay, so you are going to lose access to the market, all these category of people, and also one more, again, relisting of the company cannot be done for 10 years. After 10 years, again, maybe you may make an application for listing. Now, so quickly we are going to do a quick recap of what is the procedure. First one is identification of the company. Once the stock exchange identifies that a company is non-compliant, even after suspension, etc., warnings, they are not listening, then we are going to constitute a panel. We have seen the members in the panel. Those people are going to make a decision of whether compulsory delisting is required or not required. Okay, once they make a decision that okay, we should go ahead with the delisting of the company, then they are going to issue a public notice before passing the delisting order, asking them to give their representation, seeking representation from public at large. Within 15 days, they should reply if they have any problem with delisting. Then the recognized stock exchange shall give the above mentioned notice for 15 days, not less than 15 days time for them to reply back to all the representations made by any person who is going to be aggrieved by the decision of delisting. In addition to this, simultaneously they would also send the notice to the company for giving them an opportunity of being heard. After hearing the public and after hearing the company, they are going to pass the delisting order. After passing the delisting order, one more second public notice is required to be given, giving the intimation to the public at large that we have delisted the company, this is the company, this is the address of the company, this was the non-compliance, these many public shareholders were there, these are the details of the promoter group members. All those details should be again put out in the newspaper as well as the website. Once you have decided a delisting order is passed, then we are going to appoint an independent valuer for the purpose of determining what is the fair value that should be given to the public shareholders for tendering the shares. They are going to determine the fair value for the delisted equity shares. The shares are going to be acquired by the promoter group members by making a payment to the public shareholders as per the fair value. Money is going to be given. After money is going to be given, in addition to that, company, whole-time directors, every person responsible for non-compliance will be held liable for non-compliance, and they will also be barred from accessing the market for 10 years, and the company is also prohibited and restricted from making one more application for listing for 10 years duration. So this is the entire process of compulsory delisting. But the next question is, can a delisted company be listed in the future? Partly you have already got an answer. If it is compulsorily delisted, that means it has been delisted by the virtue of a punishment. In that case, the ban or prohibition for further listing another time is for 10 years. Cooling period of 10 years is required. After 10 years are completed, again the same company can make an application for listing on the stock exchange. That is, in case it is compulsory delisting, it is by the way of punishment that we have removed you from the stock exchange. On the other hand, if it is voluntary delisting, okay, or where exit opportunity, in case delisting of equity shares of the company from all the stock exchanges, in that case the cooling period is 3 years. In simple terms, it is voluntary. If it is voluntary delisting, in that case cooling period of 3 years. In case it is a punishment, in that case the cooling off period is 10 years. After 3 years or 10 years respectively, you can again make an application for becoming a listed entity. You are listed, you have been delisted either voluntary or compulsorily, you can again become a listed entity subjected to the cooling period applicable. If you yourself had made an voluntary application, cooling period is 3 years. In case you will compulsory delisted for a non-compliance, then the cooling period will become 10 years. So these are the basic provisions in relation to the compulsory delisting. But there are certain exceptions where the cooling period will not be applicable. What? The restriction on the company from making a listing application for a certain number of years will not be applicable once if you have been delisted from the IGP, okay, without IPO. You have the equity shares of the list are listed and traded on the innovators grid platform pursuant to initial public offer, which is delisted from the said platform. That means from IGP they have delisted themselves and they have migrated maybe to the main board, that is NSE BSE. In that case the cooling period is not required. The equity shares have been delisted pursuant to a resolution plan under Insolvency and Bankruptcy Code. Even in that case, the cooling period of 3 years and 10 years will not be applicable, because it is not, we are doing that because we want to revive the company. We want to give a plan to the company so that it can perform well and it can operate efficiently. So in that case, we will not impose the cooling off period. Equity shares have been delisted in accordance with regulation 35, that is delisting of small companies. Okay, for these 3 situations, the cooling off period will not become applicable. So that is all with respect to the basic concepts of delisting regulations and in specific compulsory delisting. The other provisions with respect to voluntary delistings will be dealt with the further class.